My name is Lynn St. and I am an estate planning and elder law attorney here in Washington State. So I will be trying to answer all your questions today. So for those of you who have a chat function in front of you, feel free to ask your questions in the chat and I will answer them either during our discussion today or at the end. And if you're on Facebook, just go ahead and put your questions and comments and I will do my best to answer those as well. For those of you who are joining us today, I want to let you know that we will be sending you a free probate checklist, and that will have some helpful information. And for those of you who stick with us toward the end, I'm going to go ahead and talk with you about a free gift that we have for you as well. So let's go ahead and get started. So this is about the 10 mistakes executors make and what you can do to avoid them. So first of all, I want to start by saying, well, what is an executor? I mean, are you in the right place? Do you know what an executor is? So in Washington State, we call it personal representative. We call it an executor. That's kind of a common term, executor. So that's a term I'm going to be using. And the executor is the person who administers a decedent's estate. A decedent is somebody who has died. And so typically what happens is once somebody has died, there's going to need to be some sort of estate administration. Very often it is what we call a probate. A probate is where a will is filed with the court. And fortunately, if you are here in Washington or in Idaho, probate can be a very simple process. I say simple, but what I mean by that is there doesn't need to be any court intervention. It doesn't need to be costly, like a percent of the value of the estate. In Washington, our rules, and in Idaho, our rules are just very much set forth. You do this, you do that, you do this, you do that. Oftentimes, when somebody is serving as an executor, they will work with an attorney's office such as ELG estate planning. Sometimes people try to do a probate process on their own, completely understandable. If that is you, we do have another recording that is about do-it-yourself probates. So our goal is to provide you as much information as we can so that you can make the best decisions for yourself. So let's go ahead and get started. 10 mistakes executors make and how to avoid them. One of the biggest mistakes people make is timing, taking too long. And we see this in a couple of different ways. One of the ways we see executors taking too long is they take too long to open up the probate. A probate should be opened up probably within a month to 2 months, maybe 3 months after the person has died, after the date of death. We encourage our clients, you don't need to do anything immediately after death. Deal with the grieving process. Your loved one has died. Take time to take care of yourself and that grief. Once you kind of feel like, okay, now you can move forward, that's the time to open up the probate. Don't take too long to do it. There are situations I've seen where people have taken a year, 2 years, or even more to open up a probate. And you can imagine what happens during that time frame of taking too long to open up the probate is, where are the assets? What have happened to the assets? Has somebody come in and taken the assets that they shouldn't have taken, either by joint titling or other ways? It makes sense, I think, that when somebody has died, then when you are ready in a month or two, move forward with administering the estate, typically through a probate process. Now, if you don't know whether a probate is necessary or not necessary, please reach out to your attorney. I know for our clients, we will meet with them, and if there is complimentary typically, and if there is no probate required, we're going to let them know that the estate plan was set up to avoid probate. So there's really not work that has to be done. It's kind of set up automatically. Lots of times clients don't know, well, is there a probate going to be needed or not? Reach out to your attorney. They will answer that question for you. taking too much time. Now, when you are the executor, the real problem we see is that the executors take too much time to do their job. Serving as an executor is a job. Not only do you take an oath, but you have told the decedent in a way that you're going to carry out their wishes. So that's what you are obligated to do. And when people take a lot of time to fulfill their duties, you can imagine problems arise. So taking too much time, oftentimes how that we see that is people are overwhelmed. They don't know what to do, and they don't reach out to somebody to help them. If somebody's doing a do-it-yourself probate, they really might not know where to start or where to turn for answers. And if that's you, if you're finding it's just too much, you don't know what to do, then do seek out a lawyer to help you. When we're working with clients, and if they are taking too long, we will let them know that here's your list of things you should be doing. We actually provide our clients now with a checklist. Do this and do that and this and that and this and that. And we are here to help you, guide you through this process. The problems that we see arise are when people simply don't do what they are supposed to be doing. There are some very specific time frames that are set forth in the laws, in the probate laws, that say when something has to be done. For example, notices need to go out within a very short time frame. And those notices, if you're doing your own probate, you probably aren't sending them out. If the law firm is doing them, of course they're going to get done. That's why you hire the law firm, to make sure that it gets done. When I'm talking about taking too much time, the executor taking too much time, it may be that they are just not doing the things that they are supposed to be doing. And if they're not, for example, they need to redirect the decedent's mail to them. Has the person gone to the post office and done that? They need to perhaps ready the house for an estate sale, or prepare the house for sale, or you can imagine all these issues. They need to review all of the decedent's paperwork. What were their assets? So there really is a need, and it's really important that the executor take this job seriously and do it like a job. Don't shirk the responsibility, move forward, don't take too much time to do it. And if you don't know what is too much time, you'll kind of get a sense of that by, if there's other beneficiaries, they're going to start saying, what are you doing? What's going on? Why haven't I heard from you? You'll know if you're an executor, you're taking too much time, if the law firm is reaching out to you and saying, have you completed this? Have you done this? This was on your to-do list. Have you done that yet? And if you're not doing it, then you are taking too much time if your attorney is giving you that feedback. Now, I want you to know, if you are feeling like, I'm just simply overwhelmed by this job, it is a big job, I have no idea how big it was, you can step aside. You can say, I thought I was cut out for this, but I've learned that I'm not. So you can actually step down from your role as executor if you're finding that it is just too much for you. And there's no shame in that you've just recognized that you weren't right for the job. So I just wanted to let you know that, because lots of times people feel like, oh, I absolutely have to do it. And if you can do this job, go ahead and do it. But if you're feeling overwhelmed and it's just taking a toll on you, then maybe it is best for somebody else to step in and take over the job.